Good afternoon, everyone. As good as it can be. It is Saturday, May 30th, 2020 at 3:35 p.m. Eastern Time. Hope you guys are having a good day with the chaos everywhere. Wanted to thank my friends at BioTrust. In the year 2020, so important to keep your body healthy. And collagen is the closest thing we get to a fountain of youth. And it also forms a wall of defense between your immune system and the rest of your body. The older you are, the more likely this has caught your attention because your hair gets weaker, your nails get weaker, your skin is a little bit different. I have been using this religiously. I really love it. It is a fantastic product, to be honest. You can go to healthwithbeans.com and give it a try. It doesn't taste like anything, so you can really put it in any drink that you want. Thicker hair, stronger nails. I like it. I'm just throwing it out there. So they're supporting us. Thank you so much to BioTrust. Again, healthwithbeans.com to support our sponsors because they're super important. Hey, guys. Hey, Bev from Minneapolis. Hello. So obviously today we have the country burning down all over the place, people rioting. However, before I'm going to do the Flynn stuff today, but I want to bring in my Facebook, DLive, and Periscope audience. Hey, guys. Just give it a second for those folks to come on in. So obviously, we're having some chaos all across the country. DC, Atlanta, Detroit, New York and Brooklyn, Minneapolis, LA. All of the big cities all over the place are in distress right now. But what we're seeing in this wave of violence, as opposed to others that we've dealt with throughout history, is that everybody's got a smartphone and people are blowing the whistle on intruders, which is then allowing the rest of the country to look at this and say, okay, well, this is obviously orchestrated and planned. You know, these things don't spring up overnight with little to no planning. Piles of bricks don't show up in front of buildings with little to no planning. So this is all contrived, and I'm going to assert that I don't think it's having the intended effect. I think that the American people are sick and tired of being screwed around with, and because of that, this is backfiring. Hypocrisy doesn't sit well with folks, and neither do there are a lot of, black people on video saying that they are very upset that there are these white kids and adults coming in wearing masks, looting their neighborhoods that have nothing to do with them. So this is really not going according to plan. I mean, it's clear the mayors are coming out and saying that everybody they're arresting is from out of town. It is not a local thing. These people have been dispersed. They're coming in from all over. There are targeted cities where they're going. And just saying. So that wasn't going to be the topic of the video today. I want to go over everything that's happened in the case of General Flynn. When I was on live yesterday, I promised you guys that I would show you analysis of the friend of the court brief that went in by, the Ron Colemans and Margot Clevelands and William Shipleys and, all the other people in the world. Trey Gowdy is on it. There's a lot of other folks. So let's go over this. I made some notes. I made some highlights. This is the argument that these folks are making for why the court should dismiss the case against General Flynn. So I have some highlights in here for everybody. We'll go over some points, and then I'll show you the transcripts from yesterday, compare them to the charging documents, compare them to the David Ignatius column that started this mess, and then we'll see where we're at from then. But I want to say, don't expect anybody on the left who has been calling for General Flynn to be prosecuted to concede. They're doubling down. They don't matter. The only people that matter at this point, again, are the middle 25%. That is the only people that matter. They're the only people that have the people that are propagating this narrative that this call with, or any call with Kislyak was inappropriate are lying, and they know they're lying. They know they're not being genuine. They know they're not telling the truth. They're doing it willingly. They're willingly lying to keep the narrative going. And I'm going to show you a clip of Barack Obama's State Department talking about how everything that General Flynn was doing was fine and actually offering to assist him if he needed to make contact with anybody. Perfectly normal. Barack Obama was choosing his cabinet in October of 2008. He was choosing his cabinet with the help of Citigroup, okay? I don't even want to hear it from these people. It's just ridiculous. So first we're going to go over this brief, then we'll go over the transcripts, and then I'll say have a great weekend. So, where's my first highlight? I have it all ready for everybody. I spent time doing this today. Where is it? This is what their interest is. They are a bipartisan group of attorneys with extensive experience in the federal court system, including many who practice criminal law in this and federal courts. Some were prosecutors, some were government attorneys or judges. They have an interest in the proper application of Federal Criminal Rule 48 in light of separation of powers and the potential triggering of a contempt proceeding for perjury in cases where a client moves to withdraw a guilty plea or where a client provides testimony which a court may consider to be false. Very important fundamental principles that need to be upheld if we are to have a system of justice in this country and separation of powers and constitutional government. Super important. So it goes through some of the factual background in the case, which we all really pretty much know, so I'm not going to spend too much time there. And then we get down to arguments. Here we go. They take cases that have been decided already and use them to make their arguments for cases that come now, which is why courts are so important. When they rule on something, it becomes precedent that other courts need to follow. Super important, which is why this is so outside of the realm of normal. So Rule 48 provides that the government can, with leave of court, dismiss an indictment, information, or complaint, but the words leave of court were inserted without any explanation. In this case, they're arguing here, Rinaldi versus United States, the Supreme Court explained that the principal object of leave of court requirement is to protect a defendant against prosecutorial harassment, i.e., charging, dismissing, then recharging when the government moves to dismiss an indictment over the defendant's objection. In other words, the government says we're going to drop the charges, but then uses the fact that they can recharge as an intimidation tactic against a defendant. So what makes this different, why this case is different, is because the government is looking to dismiss with prejudice, meaning that it can't come back again. The government cannot charge him again for this. It is done. It is over. It is with prejudice. It can't come back. So they go through some of that. The constitutional separation of powers preclude a court from overriding a prosecutor's decision to dismiss. So they say the Supreme Court ruled that an agency's decision not to prosecute or enforce, whether through civil or criminal process, is generally committed to an agency's absolute discretion. In other words, the court is not equipped to decide whether or not somebody should or shouldn't be charged with the crime. That's why we have grand juries. That's why we have prosecutors. The court is there to be an arbiter of justice, to be a neutral party, to make decisions based on the facts presented, to not take a side. This is the point of the judicial branch. And the court is not suited to make those decisions. Here is a constitutional reference they include, that the Constitution's Take Care Clause places the power to prosecute in the executive branch, just as Article 1 of the Constitution places the power to legislate in Congress. A judge could not properly refuse to enforce a statute because he thought the legislators were acting in bad faith or that the statute disturbed the public interest. In other words, if a judge does not like a law passed by Congress, he is not allowed to not enforce it just because he thinks that it's a bad idea. Otherwise, what is the point? Then we've got a judiciary with way more power than in the executive. Separation of powers is completely destroyed. What's the point? Therefore, how could he properly refuse to dismiss a prosecution merely because he was convinced that the prosecutor was acting in bad faith or contrary to the public interest? And again, these cases, these statements, these decisions, they form the bedrock for future decisions. So anytime a decision on appeal or a decision in a court case like this is put down, it sets the framework for the rest of arguments moving forward into the future. Here we say, paradoxically, the plenary prosecutorial power of the executive branch safeguards liberty, for in conjunction with the plenary legislative power of Congress, it assures that no one can be convicted of a crime without the concurrence of all three branches. Again, criminal contempt of judicial orders constitute a limited exception, which we'll get to in a second. When a judge assumes the power to prosecute, the number shrinks to 2. In other words, there's a branch that is completely thrown out. So they go through some more cases. I think I did a comment in here somewhere that I wanted to make sure I remember to tell you. Here we go. This is an example of prosecutorial abuse that they're talking about, when a court would normally step in and rule that a prosecutor could not dismiss the charges would be when the defendant was in disagreement with the prosecution for dismissing them. Examples are practices such as charging, then dismissing, then recharging a case, or dismissing a charge to defeat a defendant's pending Rule 29 motion for judgment of acquittal. In other words, if he's looking to be acquitted and the government drops the case, then they bring it up again. That's not good. They can't do that. First, the court's withholding of approval would amount to a substantial and unwarranted intrusion on the executive branch's fundamental prerogatives. This was decided in Fokker, which is the recent case that they're using. It's almost 99.9% the same as the General Flynn case, or what's being argued right now with the writ of mandamus in the appellate court. However, it was a little bit different, but they go over Rule 48 in that decision like extensively. So it's pretty recent, the decision. So the precedent is like fresh in the court's mind. So the arguments that the court has discretion to deny Rule 48 motion are flawed and unpersuasive. So here we get into some interesting stuff. I hope this isn't boring. I'm sure some people like it, but so here we get into some really interesting stuff. We talked about this on the live stream yesterday, that they're in the other court where the writ of mandamus is that Sidney Powell filed, and that court decided that they would take up and ordered the judge in this case to respond by Monday or tomorrow, basically. So Monday. There are other people that tried to jump onto that case called the Friends of Watergate, and were denied. They weren't allowed to join on. So they put their filing on that case when they probably should have put it on this one where these folks put theirs. But these attorneys, these friends of the court, are arguing against that brief here in this one on this case. So it gets a little confusing, unless for some reason I'm not seeing it on the docket in the Flynn case, the General Flynn case, like the main case. I don't know. I don't think I'm missing it though. So they say Amici who oppose the granting of government's Rule 48 motion rely heavily on the D.C. Circuit's 1973 decision in Amidon. But that decision didn't address the profound separation of powers issue implicated by its theory of judicial power. In the half-century since, the Supreme Court and the D.C. Circuit have substantially developed the separation of powers jurisprudence. Although Amidon has not been expressly overruled, it has been superseded by subsequent teaching and can no longer reasonably be considered as law of the circuit. So my note here to tell everybody is this. They used old case law, ignoring new precedent. So just like the left tends to do, and I'm sorry to paint with the broad brush, they ignore the things that are not convenient and take the things that are. Be damned when they were written, whether they apply, what they mean, ignoring in the same case other things that dispute them, or cases that follow other things that dispute them. They didn't care. They took that as their argument anyway. In addition, some contend that this court should deny the motion to dismiss because the government's rationale for the dismissal, that it can't establish the materiality of the alleged false statement to which General Flynn entered his plea, is erroneous. What does that mean? In order to have broken the law that General Flynn is charged with breaking or signed a plea with breaking. His lies, in quotes, had to be material to the investigation that these people were conducting. So he would have had to have lied about something that would have altered the course of their investigation in a material way so they couldn't continue it. Or they missed something, or they made a mistake, or they didn't look somewhere, allowing a bad guy to get away. It had to be material, right? In this case, they had the transcript of the call. So it wasn't material. My note here says they're attempting, and the other friends of the court that these folks are combating right now with this argument are attempting to decide the materiality on their own. So again, they're taking more power onto themselves. Their job in this case is not, as friends of the court, as the judge wanted, is not to determine materiality. That's not their job. Their job is to determine whether or not the judge must accept the dismissal or accept the Justice Department's dismissal. Not whether or not he actually did it. That is not their job. As usual, again, stealing power from wherever they can. It is really ridiculous. Like, you see it over and over, even in little ways. It just makes you really angry. The court illustrated this principle by explaining that a common reason for failure to prosecute an alleged criminal violation is the prosecutor's belief, sometimes even publicly stated, that the law will not sustain a conviction. That is surely an eminently reviewable proposition in the sense that courts are well qualified to consider the point. Yet it is entirely clear that the refusal to prosecute cannot be the subject of judicial review. Let's explain that. I'm going to give you an example that's probably going to make your blood boil. Andrew McCabe. They decided not to charge, or Comey, either one. They decided not to charge Comey for leaking his memos because they didn't think that they would be able to prove that case in front of a jury. They didn't think the case was strong enough. For several reasons we've talked about at length, to be honest. That doesn't mean that a judge can look at this and say, no. We're going to put him under arrest. The prosecution here, you don't get to decide, executive branch. The judge is going to decide whether or not to prosecute you, James Comey. It just doesn't work that way. The judicial branch can't review the decision whether to prosecute or not. It just doesn't work that way. For example, it is contended that General Flynn's admissions of guilt establish his culpability and furnish a basis for the court to require the case to proceed. But General Flynn had moved to withdraw his plea prior to the government's motion to dismiss, and the government, in moving to dismiss, has explained in detail why it no longer believes the evidence supports a criminal conviction in this case. In any event, a defendant's culpability is irrelevant to the legal issue presented here because prosecutors have the discretion to drop charges regardless of the guilt of a defendant or the strength of the evidence. I.e., you have on tape someone killing someone, and you're a prosecutor, and for some odd reason you decide not to prosecute that person. It ends there. That's it. So whether or like the people arguing on behalf of punishing General Flynn are making arguments, first of all, that have no basis or bearing because they're not being decided. And also the timeline, they're not using the proper timeline. And in a second, I'm going to show you what else they're not using correctly. They don't even know what's gone on in the case. They haven't even followed the docket. Anyway, here. They attempt to equate the entry of a guilty plea to a conviction and argue that a guilty plea completes the prosecution, thus, in their view, giving the court a stake in the decision concerning whether the case should proceed to sentencing. Accordingly, they contend the court has substantial discretion under Rule 48, similar to the discretion it enjoys in deciding whether to permit a defendant to withdraw his plea or to vacate a judgment of conviction under Rule 33. There are multiple flaws here. First, the entry of a guilty plea is not a conviction. A conviction occurs only when a sentence is imposed and a judgment is entered. In other words, they're claiming his plea is the end of everything. If that were the case, then there wouldn't have been anything that followed after he made his plea. The government, the judiciary has to sentence him to jail with a sentence in a proceeding where he slams down the gavel and he makes a decision on to how long the guy is going to go to jail for. So the other Watergate lefty Democrats, angry people that are arguing this, are saying that his plea is basically the end of the case. And it's just, it ignores everything about precedent and law and standards and the justice system. It is absolutely ridiculous. The very cases they actually use to argue their point actually demonstrate the contrary. So again, cherry picking sentences from case law or case precedent that don't actually even support what they're trying to say. This is so common. That's the only reason. I know this is minutia and a lot of people don't follow things this much in depth. But the only reason I'm spending the time doing this, outside of the fact that these people are freaking awesome, is that you have to understand, like, reading through court cases and reading through, like, these things that happen, it's the same tactics over and over from these people. They do the same crap, the same Adam Schiff-like nonsense, the same things they did in the impeachment. They have no real just argument of integrity to stand on. There is no debate here. They manufacture things everywhere that they can. They piecemeal things. They leave out sentences hoping no one's going to see them. They lie about voicemails. They cut things apart. They remove words to make their context. They can do nothing without lying. Literally. Everything they do, because they're so wrong, has to involve a lie. And it just gets so infuriating after seeing this for so long that I had to point it out. In even this, it's psychotic. Sorry. Here we go. Former Watergate processors incorrectly assert at least twice in their brief to the D.C. Circuit that an order of conviction has been entered in this case. So again, they didn't follow the rules, the Watergate prosecutors. They filed this on the district court writ of mandamus case, which, if I am reading things correctly, is going to piss off those judges to no end. Like, who do these people think they are? We're going to march in and warn the court. They'd better make the right decision here. Who the hell do you think you are? I mean, really? Anyway, they incorrectly assert at least twice in their brief to the D.C. Circuit that an order of conviction has been entered in the case, e.g. the court has issued an order accepting Flynn's plea. The docket is devoid of any such order because the court never enters an order for the entry of a guilty plea, which they know. They know that. And they say it on purpose. They need to lie to better cement their flawed ideas of justice. Like, they know they're doing this. They're not stupid people. They know they're lying. They know that they're saying this. The footnote here is super important because it calls them out for their nonsense. I see a lot of people are complaining about the YouTube chat lately. I don't know what's going on with it, so I apologize for the frustration. I'm not sure what's going on with it. A lot of people are complaining about it. Anyway, this is because the court never enters an order for the entry of a guilty plea. Rather, the order of conviction, the judgment based on the plea, is entered at the conclusion of the case after the imposition of sentence pursuant to Rule 32K. I'm just saying. This is what I'm saying. I mean, a plea does not complete a prosecution. Sentencing does. And again, I have put this all up on Scribd, and I'll link this in the description box below the video on YouTube for everyone. They go through more stuff, and it says here, This is another thing they're arguing, which is absolutely ridiculous. Some argue that the government's Rule 48 motion comes too late in the day. They're too late. You should have done this already. And there's no precedent for dismissing after a guilty plea has been secured. I mean, this is just Rinaldi constitutes ample precedent. Further, in the United States v. Stevens, a case that this Judge Sullivan was responsible for, the court granted the government's Rule 48 motion to set aside the jury's verdict and dismiss the case. This is after a verdict came in that this was a jury trial, a verdict came in, and the judge dismissed the case after that. So these folks are arguing this is just way too late. General Flynn and the government should have done this a long time ago. Meanwhile, the judge who's reading this very thing did the opposite of what they're saying himself. From a separation of powers perspective, these situations are apples and oranges. When a court decides contested legal issues in a criminal case, the court is performing its judicial function under Article 3. Even if the court's ruling affects whether the case proceeds, the court is not deciding whether the defendant should be prosecuted. A Rule 48 motion is fundamentally different and unique among the criminal rules because it's the tool by which the executive exercises its post-indictment discretion as to whom will be prosecuted. I think that's pretty self-explanatory, so I'm not even going to go into that too much. The Amici stubbornly resist the conclusion that separation of powers requires a court to grant a consented motion to dismiss. It's inevitable. They confuse the confession of error with the exercise of prosecutorial discretion. They're plainly not the same things. While a prosecutor could advise a trial or appellate court that it believes error has occurred in the judicial proceedings, that is merely the position of the executive branch. It is not conclusive on the court because it is the constitutional role of the judiciary to determine such questions. In other words, a prosecutor can say, there's a problem here. There's something wrong, but the court is the one who ultimately decides. In contrast, a prosecutor's determination that a case should not proceed is the exercise of executive branch discretion, not a confession of error. It is an entirely different concept. In other words, when the prosecution's saying, I drop this case, I don't want to do this anymore, it is not even necessarily because it's not them saying, whoops, we made a mistake all the time. It is actually their discretionary power to do it. It's executive power, which the court cannot usurp at all. They can't usurp it. The ultimate flaw in the analysis that these other guys present is that they are results driven. In other words, they are bending into pretzels to try and get the result they want. The court must be guided by neutral principles of law. Here, the law is clear. Unless the government is abusing the defendant, which isn't the case here, the court has merely a ministerial act to perform. It grants leave to dismiss. Conversely, the Constitution and rules of criminal procedure require the court to protect the defendant from government overreach. Here, significantly, while the court may dismiss a criminal case or direct the acquittal of a defendant at trial, the court cannot direct a verdict of guilty. Only where the defendant consents to a bench trial may the court find the defendant guilty. That is so important. Withdrawing a plea or attempting to withdraw one is not contemptuous conduct as a matter of law. Now we're going to speak to the contempt charge, the perjury, the criminal contempt charge the judge wishes to explore raining on or charging General Flynn with. Withdrawing a plea or attempting to do so is not contemptuous conduct as a matter of law. Rule 11D expressly gives a defendant a right to move to withdraw a plea. Exercising that right obviously can't constitute contempt. Statements made by a defendant during plea proceedings under oath on the record and with counsel present can be used in subsequent criminal proceedings for perjury or false statement, i.e., if this happens, if the judge charges General Flynn with contempt for pleading guilty under oath and changing their mind, especially in this case, can be contempt, we have a big problem in this country, because any defendant who ever moves to withdraw their plea will be facing another criminal charge. It's just not how things work. Not only that, the contempt is there's a lot of precedent that they cite in here and examples, but basically contempt has to significantly obstruct the proceedings of the court. It can't just be, we think you lied to us, so you're in contempt. It has to obstruct the proceedings. This has not. Actual, not theoretical obstruction is the test, and any claimed obstruction must be proven precisely. General Flynn's statements in connection with his plea plainly did not obstruct the courts in the performance. Thus, they simply can't constitute contempt of court under longstanding precedent. The court, therefore, should not embark on any contempt proceedings against General Flynn. Now, at the end here, a couple more pages, they go into the importance of Brady. And what this judge is doing is, I mean, you know that I've said this a gazillion times, but it is just so far outside of anything normal or acceptable. The court, they say this court, meaning Sullivan's court, because this is true. This court has become a leader in promoting the disclosure of exculpatory information by developing its standing order and by requiring the government to disclose exculpatory information in connection with plea negotiations and proceedings, as well as with trials. The court recognizes that the overwhelming majority of criminal cases are resolved by plea agreements, and thus it is imperative that the government interprets its constitutional obligation broadly and discloses exculpatory evidence to defendants during plea negotiations. That was Judge Sullivan that said that. Judge Sullivan said that in another case, or in a law review article. I'm sorry. And because the government disclosures raised questions about changes made to the 302 report in the course of drafting it, the court ordered parties to file the various versions with it. And subsequently, in May of 2019, they directed the government to file a transcript, which we're going to get to in a second, of General Flynn's call with Ambassador Kislyak, which the government declined to do. They had this transcript. The government disobeyed a court order to file it on the docket in the case. Then he changes counsel. It goes through the history of what goes on here. The information which the government disclosed about the FBI's conduct of the investigation was within its exclusive possession. There is simply no way that General Flynn could have known or uncovered these facts, which undermined an essential element of the charge against him, without the government providing them to him. This is the paradigm of why the Constitution requires the government to disclose such information to the defense. And that is it. It ends. Hold on. Hi, Maureen. I see you. Okay. Now. Yesterday, DNI Ratcliffe sent over these transcripts to Senators Johnson and Lindsey Graham. I'm not going to read through all of this. It appears to me, and there's been a lot of controversy around these, it appears to me some of these are transcripts and some of them are summaries, but they're duplicative. So regardless of what you're looking at, there is a transcript that matches with a summary somewhere. If you read through these, some of them are still heavily redacted, but some of them aren't. He never talks about sanctions. He never tells them not to retaliate. He conducts diplomacy. He talks about the Middle East. He talks about how strategizing against a common enemy in the Middle East is important. These are written by people that don't seem to be American. And let me explain why I say that. It's just not proper English. Both wish each other with happy Christmas and says that both can call each other anytime. Who wrote that? I have no idea. Another one that brought something up for me that made me kind of go back a little bit and look at my theory about the warrants is this. Before General Flynn's voice message, incorrectly spelled, before General Flynn's voice message turns on, there is an open line, barely audible chat. Someone asks Chershnev, which agency are we talking about? Chershnev asks to confirm if he understands the question and responds in the same time. Which agency hackers did the hacking? Believe me, Americans did hack this all. After General Flynn's pre-recorded message ends, he leaves his message. Hello, my name is Dmitry. I'm a chief of the Russian ambassador's staff. The Russian ambassador Kislyak would like to have a word with you at your convenience. Can you kindly call us back? Our office number is... Okay, listen. A few things here. Number one, if the transcript starts before General Flynn's voicemail picks up, then they were likely monitoring the call from the Russian side. Number two, the Russians think that the hacks were an inside job because they're talking to one another before the phone picks up on our side. Now, he talks about, I'm going to find the tit for tat. Here it is. Here is like one of the big controversies, okay? Flynn says, so depending on what actions they take over this current issue of cyber stuff, where they are looking like they're going to dismiss some number of Russians out of the country, I understand all that, and I understand the information they have and all that, but I ask Russia to do is to not, if anything, I know you have to have some sort of action to only make it reciprocal. Don't go any further than you have to. Because I don't want us to get into something that they have to escalate tit for tat. Do you follow me? I really do not want us to get into the situation where everybody goes back and forth and everybody has to be a tough guy here. We don't need that right now. We need cool heads to prevail, and we need to be very steady about what we're going to do because we absolutely have a common threat in the Middle East. Let's take a look. This is the Ignatius article that started this whole nonsense. Somebody leaked that call to David Ignatius of the Washington Post back in January of 2017. According to a senior U.S. government official, Flynn phoned Russian Ambassador Sergei Kislyak several times on December 29th, the day the Obama administration announced the expulsion of 35 Russian officials, as well as other measures in retaliation for the hacking. What did Flynn say, and did it undercut U.S. sanctions? Those weren't sanctions. The Logan Act, though never enforced, bars U.S. citizens from correspondence intending to influence a foreign government about disputes with the United States. Was its spirit violated? The Trump campaign didn't immediately respond to a request for comment. If the Trump team's contacts helped discourage the Russians from counter-retaliation, maybe that's a good thing. But we ought to know the facts. Let's listen to something quickly, shall we? I know I missed the liftoff. I'm gonna have to go back and watch it. I just wanna play something for you guys. Eventually. Here it is.
You probably...
Listen carefully. This is Obama's State Department press conference.
You probably have seen reports starting yesterday, but then more of them this morning about contact between the incoming national security advisor and the Russian ambassador. I'm just wondering, from the State Department's point of view, is this something that's of concern at all, or I'll just leave it there and then follow up?
Again, not necessarily. I've seen the reports. I don't think they've been confirmed or corroborated yet. But that's as he's part of the transition team. That's really for them to speak to and how they are engaging. I mean, the president-elect is also engaged on his own with many world leaders. So I don't want to speculate, and I don't want to.
There's nothing. This building doesn't see anything necessarily, inappropriate about contact between members of the incoming administration and foreign officials, no matter what country they're from.
No.
Right?
No. And again, this has been ongoing. I mean, we stand ready if they want to work through the State Department to contact some of these individuals, but we have no comment or no problem with them doing such on their own. Yep.
This was January 13th, 2017. January 13th, 2017. So, all of that being said, again, I'm going to link everything in the description box that I can link. Let's take a look at what the court said. What the government said when Brandon Van Grack, the sniveling little U.S. attorney that hopefully is disbarred and can never practice law again and possibly faces criminal charges for what he's done here. Let's see what they say. When prompted about the UN vote, the defendant acknowledged he had such a communication, but falsely stated the purpose was to get a sense of where countries stood on the vote. That's true. He did that. That's exactly what he did in the transcripts. When the agents asked him if he made any comment to Russian ambassador about voting in a particular way, Flynn answered no. With respect to U.S. sanctions, the defendant specifically said he did not recall such a conversation with the Russian ambassador, despite having 2 such calls. And when agents pressed the matter and asked whether the defendant encouraged the Russian ambassador not to engage in a tit-for-tat, the defendant falsely stated, "Not really, I don't remember. It wasn't don't do anything." When the agents pressed yet again, the defendant stated, quote, he did not have a long drawn-out discussion about don't do something. He's telling the truth. The transcripts completely support that. The final interview report, just like the agent's handwritten notes, reflect all of the above material false statements. That is a blatant lie. That is a blatant lie. The transcripts support everything that General Flynn told them, which is why they said they didn't think that he was lying. Everything that he said was true. The transcripts of the calls with... So someone doesn't know what I'm talking about, so I'm just going to quickly tell you. Yesterday, the transcript of the calls with Kislyak and Flynn were released to the public. The Department of Justice under Robert Mueller charged General Flynn with false statements based on what they say were material omissions about the conversation that they had these transcripts on. And now that we have the transcripts in the public that they've tried to hide and ignored a court order to file because they would prove them wrong, now that we have these, we can look at what he was accused of lying about and look at the transcript of the call and clearly see that not only wasn't he lying, but he is a patriot of the highest order. There is absolutely nothing wrong with these conversations at all. Nothing. There is not one scintilla of anything corrupt inside. And this is, I wish that this never happened, because having this man doing what he did or doing what he was going to do in our government would have resulted in a country so far better off than where we're at today. I implore all of you to read through these and find anything in here chargeable. This is sick and disgusting what they've done. There's more little tidbits we could get into, but again, I spent all night last night just infuriated and angry about the rioting and about this horrible travesty of justice that we're experiencing. I cannot wait for Monday to see what the hell this judge and his attorney that he lawyered up with have to say. But look, I will keep working on these, and I will show you guys the other little tidbits that I found, but I think it would make sense to do them in another video. Otherwise, we'll be here all day. And I'm trying to keep these things shorter because you guys have lives. So don't forget to check out the Uncover DC shop, please. Pretty please. uncoverdc.com/shop. I'll show you again. Here it is. President Trump knows that the violence is organized, and I don't think this will ever work again. I think there's going to be some serious consequences. Anyway, support our sponsors. You can find me on Patreon, patreon.com/TracyBeans with a Z. You can find my PayPal address, paypal.me/TracyBeans. You can support Uncover DC here. We have a lot of cool stuff coming, by the way. Big deals. Lots of big stuff. And I really appreciate all of you guys. Try to have a great rest of the weekend. I will try to contain myself on Twitter a little bit more. No, you cannot loot uncoverdc.com. No, you cannot. But you can purchase a mug or a sweatshirt or a t-shirt. And I'd be very grateful. Have a fantastic week.